Did you know that in 2026, Canadian tenants can sue their landlords for over $25,000? That's right. A simple dispute over maintenance, a late repair, or even a misunderstanding could now cost you tens of thousands of dollars. And the worst part? It could happen to you, no matter how careful you are. Imagine this. A tenant finds a minor issue, and before you know it, they're filing a lawsuit with the backing of a law that gives them unprecedented power. What once seemed like a normal part of renting has now turned into a legal battlefield where the stakes are higher than ever. Are you prepared for the consequences? Stay with me, because by the end of this video, you'll understand why this law could change everything for landlords in Canada. Get ready to find out what could cost you more than you ever expected. You won't believe what's coming next. Number 1. The financial impact. Imagine this, a small issue with your property turning into a $25,000 plus lawsuit. This is the reality for landlords in Canada under the new 2026 law. Even minor disputes, like a delayed repair or a missed call, can lead to tenants demanding huge financial compensation. That's right, $25,000 and potentially more. Can you afford that kind of risk? The law gives tenants the power to take you to court and claim significant damages, and that's not something most landlords are prepared for. The cost of defending yourself, or even settling, could put a serious dent in your profits. What was once a manageable issue could now result in massive financial consequences that could wipe out months, if not years, of income. So, what happens when these lawsuits become more common? With a law now favoring tenants, landlords need to rethink their financial strategies. Maintenance, insurance, legal fees, all of it could drive up the cost of doing business. Could this new law force you to raise rent just to cover these risks? The financial landscape of renting has changed, and it's something you need to understand now before it costs you. We put a lot of effort into making these videos, and we'd love to hear your thoughts. Comment below with how you think this new law could affect your rental business, and don't forget to subscribe. It's just one click to stay updated. Number 2. Strengthen tenant rights. The 2026 law marks a significant shift in favor of tenants, granting them stronger legal rights than ever before. Previously, landlords held most of the power in rental agreements, but now tenants have the ability to sue for up to $25,000 over issues that were once considered minor. This means that even seemingly small concerns like late repairs or disagreements over lease terms can now escalate into legal battles. So, what does this mean for you as a landlord? With tenants now having these enhanced rights, landlords are more exposed to legal action than ever before. It's no longer just about having a well-maintained property or enforcing the lease agreement. It's about staying on top of every detail and knowing that any misstep could lead to a costly lawsuit. The fact is, tenants now have real power in the rental relationship, and landlords must be prepared to deal with the consequences of this change. It's crucial to recognize that even minor issues could lead to major claims. This shift puts the onus on landlords to be proactive in avoiding potential conflicts. Clear communication, proper maintenance, and timely responses to tenant complaints are now more important than ever. If you fail to meet your responsibilities or don't act swiftly, you could find yourself in a situation where a tenant sues you for damages under the new law. In this new legal environment, tenants have the upper hand, and it's vital that you adapt quickly to avoid unwanted financial and legal consequences. We've worked hard to bring you this information. Comment below with your thoughts on how these strengthened tenant rights could change your approach to renting. And remember, subscribe to our channel for more updates. It's just one click to stay ahead. Number 3. Increased litigation risk. Under the new 2026 law, landlords face a much higher risk of litigation. What used to be a rare occurrence, a tenant taking legal action, has now become a very real threat for landlords across Canada. Even minor disputes that could have once been handled informally or through mediation can now easily escalate into full-blown lawsuits. The increased legal exposure means landlords have to be extra cautious in their interactions with tenants and ensure that every step they take complies with the law. So, how do you protect yourself from this rising risk? Legal battles can be expensive, time-consuming, and emotionally draining. With tenants now having the ability to sue for significant amounts, landlords are at risk of facing costly lawsuits over even minor issues. Whether it's a late response to a repair request or a misunderstanding regarding the lease, the potential for a lawsuit is ever present. Are you prepared for the financial and emotional cost of a lawsuit? The new law means that legal action is no longer just a possibility. It's something landlords must prepare for, and fast. This shift in legal dynamics also means landlords need to reconsider how they handle disputes. Preventative measures like better communication, clear documentation, and addressing tenant concerns promptly could be the difference between resolving an issue amicably and facing a lawsuit that costs you thousands. The increased litigation risk changes the rental landscape, forcing landlords to prioritize legal safeguards to avoid the devastating effects of a lawsuit. We've put a lot of effort into bringing you this vital information. Comment below with your thoughts on how this increased litigation risk could affect your business. And don't forget, subscribe to our channel for more updates. It's just one click to stay in the know. Number 4. Property maintenance and repair obligations. The 2026 law places greater responsibility on landlords when it comes to maintaining their properties. If maintenance issues arise, whether it's a leaking pipe, a broken appliance, or even an unkempt lawn, landlords are now legally required to address them promptly. Failure to do so could result in tenants suing for damages. The new law pushes the burden of responsibility onto landlords to ensure that every aspect of their property meets strict maintenance standards. Are you ready to meet these new requirements? The stakes are now higher. Even small maintenance delays or neglect can trigger a lawsuit for damages under the new law. In the past, landlords had more leeway in terms of when repairs were made, but now tenants have the power to demand immediate action or seek legal recourse. For example, if a tenant suffers from water damage because of a leaking roof that wasn't repaired in time, they could claim compensation for the damages. This puts landlords in a position where every detail matters. To avoid potential lawsuits, landlords must prioritize property upkeep. Regular inspections, immediate responses to repair requests, and clear documentation of work completed are all key to keeping disputes at bay. By being proactive and ensuring the property is in good condition, landlords can safeguard themselves against the financial and legal consequences of neglecting maintenance obligations. We know this video took time and effort, so let us hear from you. Comment below with your thoughts on how this new repair and maintenance responsibility might change the way you manage your rental properties. And if you haven't already, subscribe to our channel. It's just one click to stay ahead of the game. Number 5. Discrimination and harassment prevention. With the new 2026 law in place, tenants are now better protected from discrimination and harassment. This means that landlords must be extra careful about how they treat their tenants, as any unfair or discriminatory actions could now lead to serious legal consequences. Whether it's based on race, gender, sexual orientation, or any other protected category, the law ensures that tenants have the right to file lawsuits if they feel they've been unfairly treated. Could a simple misunderstanding lead to a lawsuit? The law specifically shields tenants from discrimination, forcing landlords to reevaluate their practices when it comes to screening tenants, enforcing lease agreements, or addressing complaints. This increased protection means landlords must ensure their actions are both fair and transparent, from the moment a tenant applies to the day they move out. If a tenant feels they've been harassed or treated unfairly, they can now take legal action, potentially leading to hefty fines or settlements. Landlords will have to ensure they follow strict, unbiased procedures when it comes to renting and managing their properties. From ensuring equal treatment during the application process to maintaining a harassment-free environment throughout the lease, landlords need to be mindful of every action. Can you afford to overlook the importance of treating tenants with fairness and respect? We put a lot of work into creating this video for you, and we'd love to hear what you think. Comment below if you think this new law will change how you manage your rental properties. And don't forget, subscribe to our channel. It's just one click to keep yourself updated on everything that matters. Number 6. The rise of tenant advocacy groups. The rise of tenant advocacy groups is another significant development in the wake of the 2026 law. These organizations are becoming more influential, offering legal support and resources to tenants who feel wronged by their landlords. They are well equipped to help tenants navigate the legal system and push for compensation, making it easier than ever for renters to pursue lawsuits. With tenant rights becoming stronger, these groups are likely to play a larger role in encouraging legal action. Could your tenant be part of such a group? Tenant advocacy groups often offer legal assistance and fight for renters' rights, sometimes even representing them in court. They provide educational resources on how tenants can make claims under the new law, which can lead to a rise in the number of lawsuits filed. This growing trend means landlords will need to be even more cautious in their dealings with tenants. If a tenant has the backing of a well-organized group, your potential exposure to a lawsuit could significantly increase. As these advocacy groups continue to gain strength, they will likely encourage tenants to assert their rights and take legal action when disputes arise. Landlords must stay vigilant and ensure they're following all regulations to avoid attracting the attention of such groups. The legal landscape is shifting, and tenant advocacy is now a more powerful force than ever. Have you noticed the influence of tenant advocacy groups in your area? Comment below and share your experiences with us. Number 7. Landlord-tenant communication breakdown. One of the biggest risks under the 2026 law is the possibility of a communication breakdown between landlords and tenants. With legal avenues now more accessible to tenants, misunderstandings or delays in addressing concerns can quickly escalate into major disputes. A simple failure to respond to an email or delay in making a repair could become the foundation for a lawsuit. In today's rental climate, clear, documented communication has never been more important. How often are you documenting your interactions with tenants? When tenants feel ignored or their concerns aren't addressed promptly, they may turn to legal action as a way to resolve the issue. A breakdown in communication, whether it's missed maintenance requests, unclear lease terms, or unresolved complaints, can leave landlords exposed. With a new law empowering tenants to take legal action, even minor disputes can result in expensive lawsuits. So, can you afford to risk poor communication? Clear, consistent communication is key to preventing conflicts and legal battles. Landlords must document every interaction with tenants and respond quickly to avoid any misunderstandings. This includes keeping records of maintenance requests, lease clarifications, and all correspondence. By establishing a solid communication process, landlords can minimize the risk of disputes turning into lawsuits. How do you handle communication with your tenants? Comment below and share your best practices. Number 8. Legal costs and insurance implications. With the new 2026 law allowing tenants to sue for $25,000 or more, landlords must now consider the rising legal costs associated with defending against these lawsuits. The financial burden of a lawsuit goes beyond just the settlement or damages. The cost of legal fees can quickly accumulate. Even if a lawsuit is dismissed or settled without significant damages, the process can still be expensive. This puts landlords in a position where legal expenses must be factored into their overall business strategy. In light of this, many landlords will need to secure additional insurance to protect themselves from the potential costs of lawsuits. Traditional insurance policies may not cover the full extent of legal fees or damage claims under the new law, so landlords should consider updating their policies. Having the right coverage in place can help mitigate the financial strain of defending against lawsuits and can be the difference between staying afloat or facing financial hardship. Landlords should also be aware that these increased costs could impact rent prices. In order to cover the higher costs of insurance and potential lawsuits, landlords may feel the need to raise rents. This can create a ripple effect in the market, affecting tenants and landlords alike. The shift in financial responsibility brought on by this law means landlords need to take a closer look at their legal protections and insurance coverage. Have you considered how these legal costs might affect your business? Comment below with your thoughts and share how you're preparing for these changes. Number 9. Emotional and reputational damage. The emotional and reputational damage from a lawsuit can be just as devastating as the financial implications. For landlords, being involved in a legal battle with a tenant can cause stress, frustration, and even anxiety. It's not just about money. The emotional toll of dealing with lawsuits can impact your personal life and your ability to focus on your business. On top of that, a lawsuit can lead to negative publicity that can harm your reputation as a landlord, making it harder to attract quality tenants in the future. Word of a lawsuit can spread quickly, and tenant reviews or social media posts can amplify any negative experiences. Even if you win the case, the damage to your public image can linger. Potential tenants might look up your name or your property online, and seeing a lawsuit could deter them from renting from you. Negative reviews and reputation damage can impact your future rental income and make it harder to keep your business thriving. Protecting your reputation and emotional well-being in this new legal environment is crucial. Proactive measures, like clear communication with tenants, quick resolution of issues, and maintaining a positive relationship, can help reduce the likelihood of a lawsuit. The emotional and reputational stakes are high, and it's important to keep these aspects of your business in mind as you navigate the changing legal landscape. Have you ever experienced the emotional impact of a tenant dispute? Comment below and share your thoughts on how you'd handle this new risk. Number 10. Increased rental prices. As landlords face higher legal and insurance costs due to the new 2026 law, many may be forced to raise rental prices to offset these expenses. This shift could lead to increased rent for tenants, as landlords seek to cover the additional costs associated with legal risks and maintaining their properties under stricter regulations. Higher rent could result in a ripple effect, affecting both renters and the broader market, and may force some tenants to look for more affordable options. The question is, how will this change the rental market? Landlords may also find themselves struggling to balance their need to remain profitable while still offering competitive rates. If rent increases too much, it could drive tenants away, leading to higher turnover rates and potentially leaving properties vacant. On the flip side, failure to adjust rents might mean landlords bear the brunt of rising costs, putting their business at risk. The challenge lies in finding the right balance between maintaining profitability and keeping rental prices in line with market expectations. As rental costs increase across the board, tenants will be directly impacted. They might face higher living expenses, which could also lead to greater demand for lower-cost rental units. For landlords, this means they'll need to carefully consider how to structure rental agreements and adjust to the evolving market. Can you afford to ignore these changes? What do you think about the potential for increased rental prices? Comment below with your perspective, and let us know how you're planning to adjust to these changes. The 2026 law in Canada marks a game-changing shift in the landlord-tenant relationship. As we've discussed, the potential for $25,000 lawsuits, increased tenant rights, and the rise of tenant advocacy groups have created a new landscape that landlords can no longer ignore. These changes are forcing landlords to rethink their strategies, from ensuring proper maintenance and clear communication to managing legal risks. The financial and reputational stakes are higher than ever, and the consequences of not adapting could be severe. The reality is that landlords must be prepared for more litigation, higher costs, and increased responsibilities. Ignoring these changes could result in costly lawsuits, reputation damage, and significant emotional toll. The law gives tenants greater power, and as a landlord, you need to ensure that you are not only compliant with the law but also proactive in protecting yourself and your business. In this evolving environment, being prepared is not just an option, it's a necessity. To navigate these challenges successfully, landlords will need to stay informed, make strategic adjustments, and take steps to mitigate risk. Whether that's by securing the right insurance, ensuring consistent maintenance, or having clear tenant communication, preparation is key. As the rental landscape shifts, adapting to these new rules can help you maintain your profitability and avoid costly mistakes. By being proactive, landlords can continue to thrive in a market that's becoming increasingly tenant-friendly. It's crucial to stay ahead of the curve to protect your financial future and keep your property profitable. We've put a lot of effort into this video to help you navigate these major changes. Comment below with your thoughts on how the new laws will affect your rental business, and subscribe to our channel. It's just one click to stay updated on all the latest tips and updates. Your support means the world to us.